Hello and welcome. We've just got a few of our Tuesday talks left with April starting. Very happy that Suresh agreed to do this one. Suresh Venkatasubramanian is the professor of computer science and data science at Brown University, where he's just started an exciting new center for technological responsibility, reimagination, and redesign. And we're going to discuss acronyms later on. Suresh has just returned from the White House, where he co-authored the blueprint for the AI blueprint for rights, if you've been following it. So we're very excited to have him here today. He's also a leading figure of the FACCT movement, which you've not mentioned in your bio, but I think most of us know this about it. Well, thank you so much.
Thank you. Thank you all for coming. It's a pleasure to speak here. I should say up front, I'm a computer scientist and not a lawyer, so I will say all kinds of outlandish things. Feel free to correct me when I do so. Just a brief introduction to myself. I've spent a lot of time wandering around, and the reason I mention this is also because I think it sort of informs my thinking on this topic as well. I did the normal sort of do a PhD, worked at AT&T Labs for a while, which was the old place where people did research in industry before Google and others. Then I went into the University of Utah, and I spent 15 years there before I moved to Brown. But in the meantime, on things like when I was on sabbatical, I spent time at Berkeley and at Google, and then I started getting very interested in these questions of the way in which machine learning is now impacting people out in the world of society, right? Not just as a tool for recommendations or for other things, but for, in fact, affecting how we live and how decisions are made about us. I started thinking about work in discrimination, and that led to a whole bunch of other questions. I spent some time affiliated with the ACLU of Utah on their board, and I work with folks from the National ACLU as well. We have a paper actually in submission right now. I've spent some time advising local and state governments on how to do what we now call AI governance. That's not what they were calling it then, but then that's what we'd call it now. How to basically govern the use of AI systems within government in different contexts. And then, of course, as Chinmay mentioned, I spent some time at the White House developing blueprint for an AI Bill of Rights, which I'll talk a little bit about today. And then, having spent about 15 months, which is basically 10 years in White House years, at least it felt like that. I came back to Brown, and where, as Chinmay mentioned, I'm starting a new Center for Tech Responsibility. The key thing is that the acronym is CNTR, so it's the center. You see, that's how it works. And if you really feel excited, you can send center. So it all makes sense. So, and of course, the goal of the center is to reimagine computing research to be based on society's needs, right? So, in particular, sort of I guess a theory of the case, if you wish, that I've been developing is that one of the problems with the way we conceptualize problems in computer science and how we try to solve problems is that we tend not to pay attention to who's asking the question. We tend not to pay attention to who's being affected by the outcomes. Someone throws us a problem, we sit in our box, we throw out the answer, and we don't really think about what's happening on the outside. And in order to really reimagine how we do technology design, we have to pay attention to where problems are coming from, how we're formulating questions, how we're solving them, and what we're giving out to the world. And so this means, research, it means education, it means impact. I think that, academics don't often do, and I think we should do more of, and I'll say a little bit about that at the end of my talk. But I'm here to talk about, a couple of things. So first of all, what is the AI Bill of Rights and what has been the aftermath? It came out in October. And as you know, in the world of AI, if it's been a week, then there's like 10 new pieces of technology you have to keep track of. I spent most of my last week just dealing with ChatGPT nonsense, and I'm sure this week there'll be more to deal with. So we're talking about that in the last 6 months since the Bill of Rights came out, where are we on thinking about AI governance? And also talking about what's, again, in the last 6 months, a number of very interesting emerging dimensions of tech policy discussions around AI. So tech policy, of course, is a big topic. I'll limit myself to things about AI in society, but there's a lot of interesting things that are beginning to come out, where I think there's room for conversation, progress, developments, concrete things we can do. And I'll return to this point again and again. And then I'll say a little bit, which is, again, I've been thinking about since I came back to Brown, is what academics should be focusing on. So that's the outline. I'm happy to take questions, clarifications in the middle as I'm going along. Feel free to ask. I don't know if there's a Zoom and if people are managing the Zoom, but if there's a way to, I don't know if anyone's got a question. Hopefully we can take it. Yeah.
Zoom is 1 week.
Oh, Zoom is 1 week. Okay, that's fine. Even easier. So a brief timeline, right? So the work, of course, the idea for the AI Bill of Rights, which came out of Alondra Nelson's head, sort of started off very early on when we were talking about even coming to the White House. She had this idea for basically something along these lines, but the formal really public process for thinking about this was kicked off in October 2021, which is ages ago, a year and a bit ago, a year and a half ago, with an op-ed in Wired magazine, basically arguing why we need a Bill of Rights for an AI-powered world and what that would even look like. Right? And so that kicked off sort of a process, and in government, everything runs through a process, and the process kind of looked like this. There was an op-ed that came out in October 21. There were a bunch of public meetings. In fact, the videos are still available. They were on different topics like health, consumer protection, internet sort of platforms, criminal justice, and so on. And these are like 1-hour panel discussions with a bunch of experts. It was really great, and I really encourage you to look it up on the White House webpage. We had listening sessions where anyone in the public, I don't know if any of you have seen the show Parks and Recreations. So basically we had listening sessions where anyone in the public could come and speak their mind for 2 minutes. It was not as entertaining as Parks and Recreation, but it was very, very informative. We had 2 of them. We had to, think about, and I'll come to this point later on again, how to make sure people actually could show up. If you put them at 12 o'clock at noon, there's going to be a lot of people in DC whose job it is to show up at these hearings and say things, but actual members of the public won't be able to come. So we actually had to organize sessions in the late evening after people's work, depending on East Coast time, depending on West Coast time, things like that to get, and we had like advocates from a high school group coming and talking to us about their concerns about facial recognition. So we did all of that. We had a request for information around use of biometrics in particular. And so that RFI closed in January, and then we analyzed it. And then at that point, we kind of had the rough bare bones skeleton of what such a document in Bill of Rights might look like. And then we spent a lot of time drafting it, and then spent an even longer time talking to literally everyone in the government who cared about this, organizing an entire process to get feedback from virtually every agency in the government that had something to do with AI. So it was a pretty massive endeavor. I think at some point we went across 10,000 comments and track changes in the document. And a lot of them were taken. Our general principle was to take whatever comments people were giving us unless there was some real issue with it. And so we got a lot of very good feedback from Commerce, from State Department, from Department of Defense, from National Security, from, you name it, from Health and Human Services, right? FTs, from all the regulatory agencies who contributed. It was a lot that was there. And there was a lot that was helpful to understand the nuances of this issue. And that's another sort of important point. And then finally, after a clearance process, this was released in October. So it was a long process. It took a while. And then the real question is, okay, what does that give us now? So what is the, and I should mention that there are a long list of private consultations with civil society in the private sector as well. So what does the blueprint look like? Right? It's 73 pages long. No one's going to read a 73-page document. By the comments I've seen on the web, no one is reading a 73-page document. So, but what does it look like? It has the things themselves. And again, I should mention that, one of the biggest obstacles we faced was calling this a Bill of Rights, because these are not rights in a sort of a strictly legal sense, but it had sort of rhetorical value. And I think it does. It's important to sort of articulate this way. And what are these rights or principles, if you want to call it that? That systems should work, and they should work well. And it seems kind of banal to say that when you put something out in the world, it should work, but many systems that we put on the world do not work, and they're not tested to work. And that's kind of sad and abhorrent and crazy that we have to say this, but that's what we have to say. The next thing, again, that's probably not surprising to folks in this room, systems should not discriminate, right? And again, this issue of what does it mean to algorithmically discriminate, I'll return to in a second. But it also was a tricky thing. What does it even mean when an algorithm discriminates? I mean, in certain legal sense, it doesn't make any sense, but we talk about that. Use of data. So there's a whole regime around data control, data privacy, data regulations, and data protection in general. That was not quite what we were getting at here, mainly because that is a whole separate regime of itself, especially on privacy. What we're focused on is the reckless use of data and the data flows that were essentially turbocharging the AI sort of economy, if you wish, and trying to understand that abusive practices around the use of data are at the source of many of the harms we've seen with use of machine learning, right? Data being used out of context, data being reused, data being corrupted and used in ways it shouldn't be, and so on. Then there's this sort of what I'll call a process foul of requiring transparency about when automation is being used and how it's contributing to outcomes. It's kind of important. If you don't know a system is being used, and with ChatGPT, this will happen more and more. We don't know how to regulate it if we don't even know it's there. And so this idea of a right to notice, if you wish, or a right to an explanation, as the GDPR put it, is very important. And finally, a thing that we haven't really seen elsewhere, but is becoming, I think, increasingly important: the idea of having human consideration, having the ability to opt out, to have backups, to have a person who can consider and remedy your problems. Now, you can't do this for everything, but it seems to be a very important part of putting automation in place, that automation can benefit but only if there's recourse when the automation fails, which it almost always does eventually. So that's for the rights. And a couple of interesting sort of scoping things that came out. And again, these are, I keep telling you, I'll talk about this in a bit, and I will, because these are all things I want to dive deeper on. We deliberately and very consciously chose the scope of the ALI Bill of Rights to not just be about AI. It was about any automated system that could meaningfully impact civil rights, liberties, privacy, opportunities for advancement, education, housing, credit, so on, or access to critical resources and services. This is a very important point. We did not index on the technology, but indexed on the impact. And I'll get to that again, and why that's important and why that has, I think, been the right sort of move to make here. I'm always glad when I can cite Fox News as talking about these things. So there was a focus on communities, and this is a sort of a screen clip from Laura Ingraham's show. I think she was complaining about this. I can't tell, but the point is that, and this quote is from the blueprint, basically says that designers, developers, and deployers of automated systems should take proactive and continuous measures to protect individuals and communities. And I want to highlight that point because we often have thought about the interaction between algorithms and us as an individual interaction, right? An algorithm does something to me, so I have standing to complain, or I want to complain. It's being discriminated towards me. But many of the harms that we've seen, and the reason why it's been hard to address these harms, have been distributed across communities defined in various ways. And so we felt it was very important to add in a note that the harms are not always focused on individuals. They sometimes accrue across the community, and that any kind of remedies and mitigation have to take that into account as well. So what is the structure? Why is it 73 pages long and not 5 pages long? Well, there's the principles, of course, that guide the design, use, and deployment systems, and a technical companion, which does 3 things. Sort of justifies why each principle is important by giving out specific concrete examples of cases in the past. So you link to news articles or link to research in the past, that where the absence of this principle has been an issue, or if this principle were present, it wouldn't have been an issue. So there's a whole bunch of examples. And these, by the way, have been very useful as a ways of concretizing discussions about harm. So we're not speculating on what could be, but pointing to what has happened. In addition to articulating the importance of each principle, we have a detailed list of expectations. The idea of doing this was to say, if you're a developer at a startup or a company that's worried about these things, what should you be doing in your design, deployment, development phases to make sure that you're trying to mitigate the harm that we're talking about here? So it wasn't just, okay, all algorithms must be fair, and we go away. It's more like, no. What you need to do is this kind of independent testing, this kind of evaluation, this kind of check for data quality, a whole series of expectations. So, again, as a computer science, I thought this was the most important part of it. Of course, everyone knows, people have their own opinions on what's the most important part. But I think this was important because we were trying to be very, very concrete about this. Again, I think that level of concreteness is important because a lot of times when we talk about these issues, we talk in the air, and everyone just talks in the air and goes away happy that they've said something. But I think we need to be more specific about what we need to do. And then also we gave each section gives examples of how this principle gets moved into practice. So I'm going to do sort of a deep dive into one of these just to show you how this looks when you read, or if you've read the document, you know how to sort of navigate it, right? So there's this big wall of text here on algorithmic discrimination. And the first important part is the stuff in bold italics says you should not face discrimination by algorithms, and systems should be used and designed in an equitable way. Okay, that's the high level point. What that means is, and again, you can ignore the stuff I've grayed out for now, is an articulation of what the issue is. And so this issue of algorithm discrimination occurring in automated systems contribute to unjustified differential treatment or impacts, and so on. So there's a sort of a statement of what the high level principle means. And again, don't pay attention to the gray stuff just yet. And then, as I said, we go into articulating why this principle is important, listing out specific examples in all these cases. These are, again, news reports of various kinds, talking about where algorithms that were not tested and evaluated for bias had all these kinds of problems. And again, the goal is to kind of give you a whole palette of problems, so not just to fix it on one particular. And then I mentioned, of course, the expectations, right? So what should you be doing? Well, you should protect the public from discrimination. You should demonstrate that systems protect against discrimination. You should have things like independent evaluation and reporting, and you should have a whole bunch of other things, proactive assessments of equity, representative robust data, guarding against proxies. These, again, things that are more technical. There are things that are more legible to folks who work in these spaces, who are doing responsible AI development in companies, for example. But that's why they're there. So say these are some of the things you need to do. And so when you go back to that wall of text, now you can start seeing why it's a wall of text, because you not only have the justification of what the high-level principle means, you have all these requirements that are in it. So that if you just want to read this, it gives you a high-level view of what's going on. And then we talked about moving principles to practice, different places where people are already trying to address some of the concerns around discriminatory use of algorithms. And the point, again, of bringing these examples in is to say that there isn't just one lever of change here. So one of the critiques, I think, of the blueprint was that this document is toothless, it has no power, it's not a law. And sitting on OSTP, it didn't make much sense to point out that we don't write law, that Congress writes law. But it was also important to point out that a law, while one way of thinking about how change happens in the space, is not the only way. And that there are many, many things ranging from voluntary actions, standards development, individual sectors with regulatory powers doing their own efforts. I think the US, unlike, say, for example, in the EU, we live in a very distributed federal system where you don't really have this ability to, it's very much hard to do top-down stuff at the level of Congress. It can happen, but it tends not to happen that much. And so there are ways to make changes to start moving us in the direction where the blueprint is pointing us to, but they all look very different. And that's something I've been trying to sort of emphasize. So that's the blueprint itself, and I guess sort of a skeleton of how it looks and how to read it. And when I was giving talks this October, I would stop here because that was the end of it. That's what we did. Okay, we're done. But of course, it's been at least 6 months. The question is, what's happened since? So there's a bunch of interesting things that's happened, and they're sort of ongoing. They are at different levels of significance depending on how you read the tea leaves around them. One, for example, thing is, there is continuing efforts to integrate the concepts and the language from the blueprint into other statements the administration is making. So, for example, the administration put out an executive order. They put out an executive order on advancing racial equity in the federal government on day 1 of the Biden administration. But then they put out a second executive order a few months ago, further advancing racial equity and support. And in it, they said that as agencies seek to improve equity within their own organizations, they must focus on preventing and remedying discrimination, including by protecting the public from algorithmic discrimination. And in particular, they used the exact definition, which is a bit blurry on my screen, but they used the exact definition of algorithmic discrimination that comes from the blueprint. So while the blueprint itself is a white paper, an executive order is an order to agencies. And so having this language in that executive order essentially makes it more binding than a document. So that's something that it's important. We just had a summit for democracy. Again, this is one of these sort of multi-nation sort of efforts. This is the second actually summit for democracy after the first one back in 2021. And again, the document itself, the blueprint for enable rights, and there's in these remarks by Secretary Blinken, sort of reinforces that this is how the administration is thinking about how to govern AI. So in conversations I've had with people in administration and people in Congress, this is now the document that people are using as a reference point for how they think of this, which is very important, because even though it's not binding, it has this power of coming from the White House, and it's being now, things from it are being borrowed from other places. So that's at the federal level. There's a bunch of stuff happening in the states. So Sorrel Friedler, Alex Engler, and I just put out an article in Brookings sort of commentary, pointing out how California and those states are tackling AI legislation. There's a bunch of things that are ongoing right now. In fact, there is a bill right now being drafted in Connecticut that maybe of you are aware of already, that is being pushed through to do AI governance for government use of AI. The bill in California is trying to cover both government uses as well as some certain private sector uses as well. And many other states have either passed bills, like Vermont has passed already, or are trying to pass bills, or are thinking about setting up a task force that will then lead to a process of passing a bill. So there's a bunch of stuff going on. In fact, I have a group of students who's trying to map out the legislative landscape, and it's getting bigger and bigger and bigger as we look into it every day. So that's very encouraging. It's also encouraging that a lot of these states are either in the case of California, explicitly saying that they want to model the Bill of Rights in the legislation, or B, are being informed by it, either by asking those of us who worked on it or talking to other people and bringing those concepts into them. And I'll talk a bit more of those concepts in a second. We're also seeing local regulatory action. There was, of course, there's state laws and there's some city laws, but one of the first sort of regulatory moves is by the Colorado Division of Insurance that's weighing in on how to prevent algorithmic discrimination in life insurance. So there's some subtleties here on where machine learning is being used in the underwriting and the pricing phase. And so my student, Lizzie Kumar, who actually used to work in an insurance company, wrote an article for our brand new Center Substack, basically describing the law, the kinds of proposed rules that are being put out there regarding transparency and what they can and cannot do. So there's a lot of interesting things to look at in the policy space, in some sense, in these sort of laboratories of democracy, if you wish, across the states and how they're trying things out. So what, if you look at what's happening right now, 6 months in, what things have worked from the Bill of Rights and what things have not? Is a good way to sort of say, okay, we got it wrong here, we got it right here. And I'll say the first thing that I think we got right was this issue of AI versus automation. So as I recall that I said that we focused on automated systems broadly, even though we call this an AI Bill of Rights, we weren't fixating on AI as one thing. And we defined automated systems in the document as, I'm not going to read the whole thing, but it's carefully written to sort of include things like AI and stats, but also include things that aren't considered AI. I was just talking to Aaron earlier, and we were both commenting on the fact that AI as a definition keeps mutating and changing over time, depending on who's asking and who's paying for it. And so our argument I was making and others were making early on was that we should not index on AI. Otherwise, you'll end up tying yourself in knots the way the EU is right now, trying to figure out what to do with AI, what to do with ChatGPT, because they're indexed very heavily on the definition of AI. And this is good because there aren't many good definitions of AI. This one is probably one of the better ones from the 2019 National Defense Authorization Act, which also helped set up some of the AI governance systems that were in place in the Trump administration. And this is, I think as an academic, I would think this is a reasonable definition. But also you can see it's a complicated definition. I don't know what others who study this will think. And it's tricky because again, the definition keeps moving. Right? The joke that if you're trying to get VC money, you're doing AI. If you're trying to defend yourself to Congress, so it's just an Excel spreadsheet. It depends on who's asking. So I think this was right because especially with ChatGPT, the question has now become, oh my God, we have this new piece of tech. Everything is different. And those of us who've been looking like, no, everything's not different. It's another form of automated systems. If it's just doing question answering, you don't have to worry about it. But if it's impacting people's lives in some way, that's when you need to worry about it. And then you can start talking about what it's doing rather than what it is. Because what it is inscrutable, it can change and so on. That statement, I think, is about 90% true. I think it's 10% I'm lying, but there's that only 10% right now. So we can talk about what that 10% looks like. Another thing that sort of was a big controversy at the time was, risk management approach versus, and the versus in quotes, rights. Should you frame this in terms of human rights? And, should you frame this in terms of risk? Are you doing a cost-benefit analysis, or are you doing, setting out lines in the sand that you must not cross? It turns out, while these discussions are helpful, in practice, what happens is that you get a combination of things. There is general agreement that you cannot and should not be trying to, regulate and govern every occurrence of AI. I think we can agree with that. There's also an agreement that the range of applications is broad and keeps evolving, and the impacts are significant. So you have to make sure you cover all those impacts. In the US, at least, because all those things listed on the left have different legal frameworks, statutory frameworks around them. They have different, sets of regulatory authorities around them. It makes sense to try and separate these things out. So for example, the California draft that's being looked at right now, these are all the areas which are within scope for governance of AI systems. And even there, they say AI, but they mean a fairly broad definition of it, which isn't just. And so this is actually quite consistent and in line with the way we've articulated scoping. So it turns out, like I said, that this whole issue of, NIST has a risk management framework and that's different from the Bill of Rights, that's actually not the case. I think generally speaking, everyone's more or less aligned in the idea that you have some scoping around in areas of impact, and you want to focus on meaningful impact in those areas and then focus on governance around it. The question of how you do that, again, is another issue, and that's something that will come up. The other thing, I think, we made this design choice of have principles and expectations. I would say this was, I'll give us a kind of a B+ on this, in the sense that I think the principles are very clear, they're very easy to describe, they're very intuitive. The technical companion is much more detailed, and it was meant to be concrete guidance. It feels like it's still not concrete enough based on the feedback we're getting and the questions people are having. And of course, to make it even more concrete would be, it would be 73, it might be 7,300 pages. Maybe that would be a good idea and impossible to get out. So that was, again, a choice, but I think there's still more that needs to be done to make the expectations and how to do testing and how to do disparity assessments, how to do intersectionality testing much more specific. So a lot more work to be done there, I think, which is in one way a good thing. So what are some of the other implementation questions that have come up? And I'm going to verge into very dangerous territory here. I'm going to sort of pontificate on things that I think are legal questions. So feel free to jump in and correct me on any of this. But these are the questions that are coming up as entities are beginning to draft legislation. And the questions that I don't know the answer to. I feel like there are many choices, and what the right choices depends on a combination of context, history, and what we understand about how these systems work with people in general. But we need to make some decisions about them. And maybe either answer is fine, or maybe only one answer is fine. For example, what is the right regulatory regime model for these systems, right? So there's a very nice article from a couple of years ago. It's called The Flight to Safety Critical AI. And the question is, can we learn about AI safety from the aviation industry? There's, of course, this paper that many of you may have seen, basically proposing an FTA for algorithms. So already FAA, FTA, we have two different models that have their own regulatory structure for thinking about how to regulate automated systems. I have often used the example of cars and seatbelts to argue that things like seatbelts and literally guardrails on the road do not actually prevent us from driving, but they actually make it safer. In the same way, having guardrails on automation doesn't prevent us from innovating, but actually makes the use of it safer. But then you start getting into questions about, okay, are you trying to regulate AI like you regulate cars? And a thing I did not know is that cars are not pre-tested before they're put on the road. There's a set of checks that car makers are supposed to promise they have done. Then they put the car out, having done self-regulation. But then the NTSB can come in and say, okay, we're going to do a recall because blah, 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 blah. All the things can happen. So that's an example of kind of, not proactive testing. Whereas in the airline industry, there's proactive testing. Planes don't get put out without a whole battery of tests on all kinds of things. And planes are interesting because they have to, work in many different conditions, under different weather patterns, different kind of turbulence, and so on. And all those things have to be tested. Again, something that people say you can't do with AI because you can't realistically test it in real environments. Maybe you could. Again, with drugs, it's a long process before a drug is ever released in the market. It's long. People say it's expensive and it slows innovation. These are all good discussions to have. But it is a different model, right? Where companies will keep their proprietary information, but they have to submit documentation to the FDA, and the FDA has to decide whether to do it or not. I don't have a good answer for this. I think there are many different models that we're trying. The FTC is experimenting with their own right now. And I think the jury's out on what's going to be the best one, but we're looking at different models. This whole issue of adjudication, well, again, versus quote unquote rulemaking approach, this famous paper by Daniel Citron from way back, a prescient paper from 2008 that seems so relevant even today, right? But it was written before the current wave of deep learning and machine learning. So it talks about this distinction between adjudication and rulemaking being blurred a lot in the world of technology. We've seen a little bit of this, for example, in New York City. They put out a local law, I think 141 or 114, to govern the use of algorithms in employment. And they were supposed to make the law active in January, and then they had to delay it because they haven't quite figured out the rulemaking process and what exactly the specific guidelines are to companies who want to comply. So again, this issue of how specific you make your rules, how much you leave it to future adjudication if they don't follow the rules, the fact that companies would like much more specific things so they can say that they're in compliance with it, but the fact that things that are very specific often don't fit the nature of this very evolving technology is a big challenge. And again, I don't have an answer to this. I suspect there are at least some clues and answers in the literature on this, and I'm eager to hear from what people may think about that. Another thing about how to challenge, one part of accountability is being able to challenge things in court, right? So, for example, again, in California, there's an individual right of action under certain conditions, but it's not yet clear under what conditions you can challenge. There's issues of trade secrets, of copyright protection. In the case, for example, that was where a particular piece of technology was being challenged when it was used for sentencing, the Loomis Wisconsin case. One of the issues was, that the company refused to reveal the information about the tool that was being used because it's proprietary. The person, Eric Loomis, or his lawyer, sort of argued that this was, a violation of due process, and that claim was sort of mitigated by the fact that the judge argued that there were other ways to make the same determination even without the tool. So this issue of, what can you actually get information about in a tool if you have to challenge in court is a tricky one. So we just actually, Andrew Phelps, myself, and Lizzie are in the process of doing the final rounds of review on this topic, arguing why courts must interrogate machine learning, and also how it's important to understand that the design choices in the making of a piece of software are themselves essentially value judgments about what the designer is responsible for and what they're not responsible for. And since courts are accustomed to thinking about issues of responsibility and who's at fault, they have to be able to unpack the way these systems are designed, not just what they do. And so that issue of unpacking the design is a bit more subtle, but I think it's an important one that's going to come up more and more if we want to allow the challenge of these tools in court and not have the court case be a sort of a fait accompli where nothing gets ever happened, well, nothing happens. And finally, there's another sort of debate about, to what extent, the law of the horse thing, right? Do we need new law for AI? Can we just use existing law on anti-discrimination, for example? Is that okay? I think the answer is maybe. And so the FTC has been very aggressive in trying to argue for, broadening the scope of deceptive business practices to include things like discrimination, to include things like claims about AI efficacy, to include things like, claims about deepfakes or ChatGPT or what have you. The EEOC has been doing investigations now for a long time. They put out new guidelines on algorithmic discrimination that would potentially come into conflict with the ADA, the American Disabilities Act. But they're also looking more broadly into hiring systems as well. And one of the key questions, for example, is a company that does resume screening an employment agency or is just a software provider? If it's an employment agency, then it comes into the purview of the EEOC. If it's not, then it isn't. And so what's the answer there? And similarly, the Health and Human Services, especially after Obamacare, has this thing called Section 1557, which talks about non-discrimination. And then now they're looking to what it means to do algorithmic non-discrimination, or how to protect against algorithmic discrimination in the delivery of care and clinical sort of support and diagnostic support. So again, this is a question where the agencies who have regulatory authority are trying to see to what extent they can use existing powers to regulate algorithms. It remains to be seen whether these are enough or we need them. So let me check what we're doing on time. What should academics do? And this is a question I've been sort of plagued by ever since I came back to Brown, because it's almost like, I can't even say red pilled anymore because that term has been tarnished by the other thing. But essentially, having spent time on the other side of the fence talking to academics about what we need to do about some of these problems, I have come to realize that a lot of what we do and what I've done in the past is not helpful. It's good, it's critique, it's maybe pointing out problems. It doesn't give us anything actionable that we can do. And I think we are, in fact, moving away from critique, which is valuable, which is basically what is the problem here? Can we identify the problem? And I do think we're moving very quickly towards how do we solve the problem or how do we mitigate some of the issues we're seeing? And we need tools to help us with that, right? So the expectations were one way of trying to get at that. We need a lot more of specific problem solving around these questions. And again, we're going to make mistakes. There's going to be errors, and I think we'll have to learn from them, unfortunately, and we on the fly. But we have to go to that sort of constructive space of reimagining and rebuilding rather than only having critique. And I'm not saying critique is bad. I think it's important. But I think it's easier in some sense to critique. It's harder to suggest something imperfect that you can get us forward. There's also this whole issue of, well, Congress is too slow. Congress people don't know anything about technology. Technology moves too fast. We're too cool. We're too smart. You can't handle us. We're, leave us alone. Blah 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 blah. The truth is that this is not this may not even be a bug. It may be a feature. That yes, technology moves fast, and yes, that's a problem if you want to design policy to fixate on the technology. But maybe that's not what you should be doing. That if you focus on impact, it seems to make for better questions, better things you can try to solve. And better policy, frankly. The case of ChatGPT is an instructive example. Everyone's freaking out about, ChatGPT and Skynet. The thing I'm freaking about is you start using ChatGPT in a suicide hotline, and it starts telling people things. Where's your accountability there? Okay, but that's giving medical help. We understand a little bit about how to do regulation of medical treatment, medical systems, or things that claim to give medical advice. We have a little bit more to say. Let's focus on that. We're not going to solve all of ChatGPT problems, but we can solve that particular version of impact using tools that exist in that space. Suppose you start using generative AI in the criminal justice system. Okay, we understand a little bit more there. We don't have the tools yet, but we understand what those issues are and how the impact is going to show up. My belief is that this is a better way to go about this than focusing on the technology, because the technology keeps changing. And frankly, even I've been astounded by how quickly things have changed in the 6 months since ChatGPT came out. But I've also been frustrated by the fact that in the 6 months since ChatGPT came out, we've had even more occurrences of bog standard algorithms causing the same old problems with bias, with withdrawal of care because of badly designed systems that weren't audited, weren't tested, weren't evaluated. And we're still not addressing those questions. So again, we have many issues, but we have ways to go about solving them without, if we don't fixate too much on tech. We also want to sort of engage with people who are being impacted. And in my own work, I'll say that I've been very, very influenced by talking to advocates and communities. I remember actually going and watching a bail hearing once that was done on video. It was during the pandemic, I think. I don't remember anymore. Everything pre-pandemic is gone from my brain. But seeing the way the interaction happened between the judge and the defendant's lawyer and the defendant who was in a jail room with a video screen, and I got like maybe 30 seconds to a minute, all my academic discussions about, well, we have to design a good risk assessment and put this explanation up on the screen, that's going to work, but all went out the window because there's no time for any of these things. So I think this is just a small example, but understanding exactly on the ground how these technologies are being used and how people are impacted is another way to ground the mitigations and the solutions and the policies we're trying to develop, rather than sort of sitting back and just thinking about it. And to that end, one event that we're sort of organizing, the first major event that the center is organizing actually is co-sponsored with the MacArthur Foundation and the Distributed AI Research Institute, which is the institute that Timnit Gebru and her team are running. Sort of just trying to think about how to bring community partners in with academics who work in this space to understand how we can, as academics, can sort of refocus our research and make sure we're doing work that is meaningful and helpful to people who need that kind of support. And so there's 30 organizations, including many community organizations, civil society groups as well. Another thing that I think we all need to do is to understand the narratives. I was talking to a reporter recently, and I was mentioning that we're now in the realm where discussions around AI are bound up in politics, around China, around innovation, around business uses, around this desire for regulation. It is not a purely technocratic discussion. It maybe never was, but is even less so now. And so thinking of these narratives around discussions around AI and realizing the sort of the undercurrents around it is going to be very important for us. That thing on the left is that former White House advisor was me. I was trying to say something, and that was the headline. The initial headline was much worse. It was like White House advisor slams senator, and then that got me a lot of unwanted attention. So, but the point is that we have to be aware that these discussions we're having now are much more fraught and much more full of tension than they used to be, and that we have to be careful. I mean, there's a lot of different political camps, ideologies. Are we worried about sentient AI? Are we worried about existential long-termism and existential risk and so on? That's becoming a challenge for people working in this space. So I want to conclude now. I've talked at you for a long time, and I'm eager to hear you talk back. That's how you can reach me. I'm at the Data Science Institute and the Center for Tech Responsibility, and thank you for listening.